Good afternoon. The San Francisco Association of Realtors is very pleased to present today's forum on new and revised state and local forms. We have a true dream team for you today. First up, we have Daniel Hershkowitz with his name accidentally misspelled. And there's Dan. Hi, Dan.
Hi, everybody. That is an exact likeness, people. If you're wondering what I look like, it's that.
And I'm Vickie Naidorf. And that is not an exact replica. It is how I think of myself at times. And then my illustrious partner, Bill Jansen, who looks exactly like that.
I did some time ago.
Yeah, I think I have to change your hair color too. All right. Before we get into the forms themselves, I want to do one quick little housekeeping item. All three of us throughout our careers have been asked when speaking about forms, is it required? And unfortunately, when that question is asked, there are often several assumptions built into the question as well as to the answer. So recently, when Bill and I heard somebody else answering the question of whether or not a form was required, we were sitting there shaking our heads no, but we soon realized that the problem was not with the question itself or the answer, but the assumptions that were built into it. There are four different types of required forms. The one that most people think they're asking about is a form that's required by statute or local ordinance. There aren't a lot of these. The classic examples, of course, is the agency disclosure form, the real estate transfer disclosure statement, and the natural hazards disclosure statement. Those are state forms. And then we have a COPA notice that's required in San Francisco. There are also forms that are not in a specific statute or law, but the form or some or all of its content is either required by statute, case law, and possibly the purchase contract form that you're using. Examples of this would be CAR's seller property questionnaire, the exempt seller disclosure, the possible representation of multiple buyers and sellers, as well as the San Francisco seller disclosure form. The third type of required form is where neither the form nor the content is specifically required by a statute, but it is the relevant standard of care to use the form. Some great examples of this are the CAR Statewide Buyer-Seller Advisory, the SFAR Gibbs form, any advisories about TICs, probate, trust properties, as well as the county disclosures and disclaimers advisories that you would find in Marin, Alameda, and elsewhere. Then there are specialized forms that are required by your brokerage or possibly by the MLS for any reason. Examples of this would be when a broker has affiliated business arrangements, they must have a form describing those, disclosing those arrangements. Some companies have their own specialized disclosures or internal policy requirements, and then many MLSs have their own waiver form. So when we're going through the revised and new forms today, keep in mind when we ask ourselves the question as panelists, is this form required? The requirement may fit into one or more of these different types. Bill, there's some new forms and revised forms out this week. You want to take us through that, please?
Yes, thank you, Vicki, and hello, everybody, and welcome to the presentation today. California Association of Realtors has a forms release a couple times a year, and one of them is in June, and this week they dropped these forms, 2 new forms plus 11 revised forms, and we're going to go through just a few of those. We're not going to go through all of them. We're going to talk about the property visit and open house advisory. We're going to talk about the new square footage and lot size advisory and disclosure, which exists Now for the California Association of Realtors as well, you have one in San Francisco, which we'll touch on. Then the revised forms, we're going to talk about the DIA, Disclosure Information Advisory, and the revised transfer disclosure statement. We're not going to touch on the rest. A number of them relate to landlord-tenant revisions, to the CTT, which is the Notice of Change of Terms of Tenancy, the NTQ, Notice to Quit, the NTT, the Notice of Termination of Tenancy, and the two related notices, PCQ and PRQ, which is a Notice to Perform or Cure, Covenant or Quit, or Notice to Pay Rent or Quit. We're not going to talk about those right now, but a cautionary note, and I think all of you are aware of this, being an agent representing landlords or tenants has gotten exceedingly complicated, not only because of San Francisco rent control ordinance, but because in certain circumstances, the statewide just cap and rent cap and just cause eviction law is in place. If you're operating in various communities around the Bay Area, a number of cities have enacted eviction moratorium, and so you have to be aware of those as well. So there are a number of additional laws we have to worry about in addition, oh, by the way, revisions to the fair housing regulations that apply in the state. So representing landlords and tenants has gotten exceedingly more complicated, and general recommendation is, unless you are familiar with these laws and experienced in dealing with landlord-tenant issues, the recommendation is that you only do so with the approval of your brokerage, because it has gotten that far more complicated. Dan or Vickie, you want to just comment on that point as well?
Well, just to underscore this, if you happen to be out there and work for Compass, I say to you, please, for the love of God, no, don't do anything landlord-tenant related. And I say that with this in mind, it is crazy complicated. And the best service that you can give, absolutely the best service you can give, is to say to your seller in particular, before we sit down and talk about this tenant-occupied property and exactly how we're going to attack this, let's have a meeting with a local landlord attorney to help us put together a game plan for the most efficient way to market and sell this property, so that we don't regret that we didn't deal with the tenants up front. The tenants are incredibly difficult in good times, and now with all of the regulations, there are so many overlapping rules that you really need to be a specialist in this area. And there's no shame in not being a specialist. We make referrals all the time. Let's just make a referral here too when someone asks you to do something that is landlord-tenant related.
Dan, just out of curiosity, do you consider yourself to be a qualified local landlord-tenant attorney?
In fact, no, not even close. So I just know enough to be dangerous, right? So what I really strive to do is to keep myself abreast of these issues so that I know what questions to ask. And it really is very difficult to keep all of these things straight in my head. I just know that there are these overlapping issues, and I know enough to know, oh, hold on, here's some of the questions we need to ask to the attorney. Let's go do that together. And that truly is providing good service. I joke all the time that when you go to your neurologist and on your way out, you say, oh, can you look at my finger? I've been having this problem. You actually want the neurologist to say, no, God, no, I don't know anything about fingers, right? But it's a good neurologist who will pick up the phone and say, let me call my friend, she's a finger specialist, right? That's good service. And that's the example here for your client. You know, I'm not a landlord-tenant specialist, but let me connect you with one.
And I think Vickie and I
speak for Bill and myself. We're not landlord-tenant specialists either. And the reason I asked Dan that is because I already knew what his answer was going to be. Our answer is the same. Now, why is that important for you to know? Well, first off, don't ask us questions about landlord-tenant stuff. We're not going to be able to really answer it. But more importantly, we are, all three of us, qualified California real estate attorneys, but we know what milieu we work in and we know where we don't. And it's important that all real estate agents keep that in mind as well.
And I would like to emphasize the word local. You need to have an attorney who understands local laws, because local ordinances can be more strict than state law. And once you go outside of San Francisco, there is a patchwork of various laws and regulations out there that only a local attorney who practices in that area will know. And Vickie and I also, with respect to the brokerages that we represent, give the same advice as Dan gives to Compass, and I think it is really good advice to follow. So moving on to the another form that has been released by the California Association of Realtors. It's an updated BPP form, which has got the long name of the Mandatory Government Showing Requirements, including Best Practices Guidelines for Prevention Plan. There's the BPPP hidden deep in that name. This started out as an 8-page form, and it was reduced to a 5-page form. Vickie and I consulted with the CR Legal and suggested some shortening of this, and we are pleased to see that they just released last week a 2-page version of this, and it exists attached to the PEAD-V form as indicating the parties who sign that form are indicating that they have received this and will comply with this.
In fact, it's attached to all of the PEAD forms, as a matter of fact.
Correct. Thank you. Yes, it is that as well. So is this a required form? The answer is, well, it's not required by statute. In fact, various listing offices could come up with their own version of this form, although this form, because it is put out by the California Association of Realtors in many parts of the state, have become the standard of practice. So it is required to have a form that does what this one does. Some local brokerages may require a different form. We have encouraged our clients to opt for this form, particularly now that it has become less unwieldy and it's
I think means
understood by all agents.
I believe less unwieldy means that it's now wieldy.
Yeah, it is wieldy. Yeah. I was trying to avoid that word. That's sort of like, what does the word gruntled mean? You can be disgruntled, but has anybody ever been gruntled?
Nonchalant.
Thank you, Dan, for that. In any event, that's this form. Vickie, any comments on that?
No, I'm always pleased when things get shorter because I live my life shorter and I think it's better shorter. But
Bill, you'll also notice that there are no longer any signatures, and one of the improvements along the way in the last version was to remove signatures. And for those of you who want to add them back, remember that this is attached to other things that will have signatures. So the signatures are taken care of in the PEAD form themselves. This is also attached to the real estate listing agreement addendum related to coronavirus. And so those things already have signatures.
Yeah, and each one of the forms that Dan just mentioned specifically state that the BPPP is attached and is part of those documents. So again, also, you don't need to get them signed.
Right, and also please note that they've made substantial changes as to who's responsible for cleaning and sanitizing between visits. So I recommend, if you have not done so, it's only 2 pages. They're all bullet pointed with numbers. Read it, understand it, and use it.
And the last thing on that regard, if I could, if you were on any of the calls with the California Association of Realtors attorneys, they were reminding everybody that even if we agree otherwise, that we're going to outsource some of these requirements, like the cleaning from the listing agent to the showing agent, that ultimately the responsibility does remain with the listing agent. So it's a little bit of a careful issue there. I think the best outsourcing would be to a professional company if you're going to outsource.
Well, there's also another new change. This one was not announced by CAR, but I do want to make sure that everybody is aware that the Homeowner's Guide to Earthquake Safety pamphlet, which contains the Residential Earthquake Hazards Report, was revised. The 2005 edition has now been replaced with a 2020 revision. The information in that pamphlet is much more up to date. It has different maps and has, I think, created a pamphlet which will make it much easier for both buyers and sellers to read and understand. Because of the change to the pamphlet, the old residential earthquake hazards report is no longer in existence, and instead we now have the residential earthquake risk disclosure statement. There are some minor word changes here and there to the questions, but the questions are essentially the same as before. I think they've been reworded to make it easier for sellers to be able to understand. For example, with the water heater, it now only references, has it been braced rather than all the other terms. And you will notice the name change, Residential Earthquake Risk Disclosure Statement. This form is required by statute, but only if the property was built before 1960. Moving on now to the new CAR forms that Bill previewed. Yes, there is a new CAR square footage and lot size disclosure and advisory. For people who are using SFAR forms, I know this isn't going to seem like a new form. It looks a little bit different from the square footage and lot size disclosure that SFAR has had since 2017. It looks a little bit closer to the lot size square footage disclosure advisory that was created by PRDS, which happens to look identical to the form that Bill and I worked on starting in about 2016. So, gee, CAR now has this form. And if you look at it, the headings look awfully familiar. The first paragraph says different sources of square footage measurements. Why is that important? Well, there's all sorts of sources, and each source tends to have its own size. There is a myth in real estate that is held by many people, agents and buyers and sellers, that there is one true size of the property. However, as we have learned in countless numbers of claims and lawsuits, the size the architect says, the size the public record shows, the size that is come up with by the appraiser, those sizes are all over the place and they can vary dramatically. So we have to move away as an industry from believing that there is one true source, and that's really the import of this particular form. Another part of this form is to remind buyers that they shouldn't just rely on what's advertised or what's contained in this report. If size is an important factor for them in either deciding to buy or what price to pay, they really should retain their own size experts during their contingency period. Interestingly enough, this form does something which I'm very pleased to see. It affirmatively tells buyers that other sizes may exist. Now that may not seem like a big deal, but one of the problems that we have in trying to defend real estate agents is the fact that most of the time, the buyers have been, in their minds, led to believe that there's this one size and that they didn't know that there were other possible sizes. What this form does, like the SFAR form and the PRDS form, it creates a grid. The big difference here is that either the listing agent or the seller or even the buyer's agent can insert the known size information as well as the source. One enhancement of this form over the others, there's a column to check to indicate that the document that has been referenced as the source of the information can actually be attached and provided with the form. What is missing here is something which I think is a little bit important. And there were actually two things that were missing before. But one of the things that they put in at the very last moment is that the seller represents that the seller is not aware of any other size measurements. That's really important. But I will tell you that this form, I don't believe is as good as either the SFAR form or the PRDS form. Is it a required form? I think it's important to recognize that there are two cases which have dealt with these issues in the past. And there's the two most important appellate decisions. Both happen to involve my former employer, Coldwell Banker, for some reason. The first one is the Vickie versus Coldwell Banker Southern California case, where regardless of agency relationships, known size discrepancies must be disclosed. And the Salahutin case, which says that the fiduciary must affirmatively state whether or not the information that is being provided has been verified or not. 99.9% of the time, agents have not verified the information that they're passing on. And this form takes care of both of those elements. So in that respect, this is a required form, but not this particular one. As long as you have a square footage and lot size disclosure advisory, you are meeting the relevant standard of care. Dan, did you want to add anything onto this discussion?
Just for fun, is it a few things that we have in there? You see where it has additional information? That's where you have an opportunity to type something, right? And so seller, for instance, if the seller is providing the square footage information, the question is, from where did that seller obtain that information? And this would be a great place. In fact, the form is pre-printed with a little prompt right there asking the seller from what source they get. And the reason this came up is because every so often a seller will simply say, no, it is not 2,800 square feet, it is 3,200 square feet. And the answer is, okay, from where does that come? And the seller says, I know that to be true. And so that is not exactly the standard of proof that we're looking for. We'd like some reference to something. And the other fun thing to remind people of is that the good news is your signature is not required on this form. So you see that this form says buyer and seller. The truth is, as a listing agent, you will often be participating in making sure that the numbers that you have all end up here, which is your requirement and the seller's requirement. And it will be reminding your seller that, hey, we have an old appraisal. We need to put that number down there. We're about to get a floor plan diagram. Perhaps we don't ask the floor plan diagram person to calculate square footage. Otherwise, we're going to have one more source. And if it comes back at a number we don't like, well, too bad, we're stuck with it. So that's something to consider. Okay.
So what is missing from this form as compared to the others is there's no indication who actually is the person who is filling in that information. Isn't that correct, Dan?
Right. And so that's sort of the point with the signature. So we just have the seller's signature, right? And the seller is not aware of any other measurements. And I suppose by implication, the seller is saying, I am aware of these measurements, but you're right, there is no such thing.
And from my perspective, I think it's only fair to have whoever is the agent who filled this in to state that they're the one that filled it in. Yes, it doesn't matter who fills it in. We should always double check and make sure that the seller's not aware of any other measurements, because when there is a size case, the first thing that the seller always does is throw the listing agent under the bus and says, well, I told the agent there were 3 other sizes and the agent chose not to disclose that. So that's why the seller representation is important, but all of the other forms do have a place for whoever is putting in the information to state that. And I think that that's a much fairer approach. Bill.
But I would add to this as well. We recommend that our clients use this form on every transaction. Every square footage number that's known or is out there, you can look in the MLS. The history of MLS may have other numbers, appraisals, prior marketing statements, all of them should be put in there. Which one's the correct form? As Vickie said, there is no such thing as a correct square footage number because there is no consensus as how to determine square footage. 3 appraisers are going to have 3 different numbers, for example. So this form is important because it does a number of things. Besides disclosing the known square footage numbers that are out there, it advises the client and makes them aware that they really can't rely on those. And if they want to rely on it, they should be investigating the numbers themselves. And obviously, we don't want you, the agent, to measure anything. Even if there's only one square footage number, maybe the one that's auto-populated in MLS, use this form anyway, because the hallmark of a lot of the claims we see is there's one square footage number in the MLS. In the middle of the transaction, the appraiser comes in with a lower number. Dan said, for example, 3,200 square feet in the MLS. Appraiser comes back at 2,400. The way that plays out is the attorney for the buyer says, there's a discrepancy. It was a misrepresentation. There's 400 square feet missing. We're selling at what, $1,000 a foot, right? So we want a reduction of $400,000. And then the attorney for the seller says, we didn't advertise that, you, the agent, did. So it is on the broker to bear the burden of dealing with this alleged misrepresentation. This form has saved so many claims in what is one of the most common kinds of litigation that we see, an alleged misrepresentation on square footage. They're expensive. They can be very expensive. And if you have this form completed, signed by the buyer, not only have you educated the buyer regarding square footage issues, which is your job as a fiduciary to the buyer, but you also have provided a vehicle to point out that the buyer was properly advised, and the cases where we have these signed by the buyer, they're able to be resolved more quickly and for less money.
Just jumping in real fast. And what this reminds me of is sometimes you don't get this form from the other side. And so when representing a buyer, you still need to provide this to your buyer. As a fiduciary, you have an obligation to provide your buyer with any known square footage numbers that you have. So maybe you have one and you want to provide that, but maybe that's not the issue. Maybe the only number you're aware of is the tax records, and they've already, or the public records, and they've already signed off something indicating they've received that. But nonetheless, you want to make them aware of the concept that there is no such thing as a true square footage number, as Bill suggested. And that would be the perfect time to have this conversation with a client, because this happens all the time. Often you have removed all of your investigation contingencies. You have still an appraisal contingency or a loan contingency. The appraiser comes out and gives you a square footage number that is 400 less than what was the public records and what was disclosed by the seller. That doesn't mean the seller did anything wrong or the public records are wrong. It just means that this appraiser says it's 2,800, not 3,200. And now if you have a client who's very sensitive to square footage, what is the remedy? They have none. They nonetheless, if the appraiser has come back and appraised it for value, they don't have an appraisal contingency issue. If the lender has approved the loan, they don't have a loan contingency issue. They're just sitting there now with this lower number that someday they're going to have to disclose, and they're upset and they want to know what the remedy is. So this is the perfect opportunity to have a discussion with them that if you're sensitive to square footage and we don't have a contingency specific related to that, then you're going to be stuck with the square footage number, whatever the appraiser comes back at. There are ways to remedy that, but this form is a good time to have that conversation.
And one thing you might want to consider in a more proactive way is to provide a blank version of this to buyers when you're showing them property and when you are giving them information from the MLS about a variety of properties, so that they understand that they shouldn't get too wedded to whatever number is in the advertisements. All right, we have another new form from CAR. Bill, you want to talk about the PVOH?
Yes, this is a new form. It is the Property Visit and Open House Advisory. It does a number of things. If the visitor signs it, they have been advised that there may be recording devices in the property, either video or audio, and counsels them to be aware of that and act accordingly. It talks about accompanying minors. If there's any hazards in the property, they are advised of those hazards, and that they should also pets at the property, and also they should be aware of controlling minors. And they're understanding that there is a risk of injury, and they're assuming the risk. So this form does all of those things. The question then comes up, is this a required form? No, it's not necessarily required by statute. The content is not required by statute. It could be required by the broker, but I think it's strongly advised to use this form for clients coming into the property, others coming into the property, when you have any of those things in existence. Pet animals or pets that you have to be careful for, safety issues, recording devices, or if they're coming in with minors. But basically, it doesn't really fit into a required form other than that. Vickie or Dan?
Well, just for fun, giving you two examples that'll drive this home. First of all, by the way, when we drafted this, I happen to be the chairperson of the forms committee this year at CAR. And when we drafted this, our goal was to make sure that we had one form as opposed to so many brokerages having their own versions. Whether or not you need to use this form is a whole other story, but the idea was to at least unify with one form. Okay, so with that in mind, now there's this thing called, this by the way pertains to open houses. I don't know if you remember what an open house is, but we haven't had one in a long time. So this form may never be used or may not be used for many, 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 many months. But what I want to drive home is at least the first concept, which is the recording devices. And here are the two great examples. True story. Listing agent sitting there, he's talked with some people, they come through the property, they've left, he feels good about himself. He hears a voice from above that says, I'd prefer if you would stand a little bit to the right. When you greet people, I think it's a better vantage if you're standing next to the kitchen rather than next to the bathroom. And he realizes that was his client, the seller, who's been watching on the, what do they call it? Not Zoom, Ring, on the Ring.
Nanny cam.
On the nanny cam, right, on the Ring. And he says to himself, oh dear God, I think I went earlier and ate one of his Pop-Tarts. Did he see that too? So this is an issue, right? So your client may be watching, and similarly, if you are representing a buyer and you're standing at the front of the property thinking you're having a private discussion, or you've in fact closed the main bedroom door so that you can have this conversation, and you say things like, okay, I think we should offer this, and if this happens, then we can come up this amount, the seller may be listening. Okay, so if you've taken nothing else away from the existence of this form, no, the seller may be listening.
I would add one more on that, Dan. That's very good advice. If you have a property that has renovations going on, construction, ladders, scaffolding, other issues, tools laying around. We had one situation where a client walked up onto a second floor that was construction. There was a big hole in the floor. They fell down to the first floor. You're advising this should be used in those situations when you have a property with construction or other dangerous conditions existing. I would use it every time in those circumstances.
Well, here's a however, though. Here's what I would say, Bill. I got to tell you, every time an agent comes to me and says, do you have a disclosure or disclaimer or some transfer of liability for a dangerous condition, I say the following. No, we cannot having somebody sign something that says the house is unsafe. We're doing this. We're not showing unsafe houses. Okay, so that's instead of having an open house where you can fall through a hole and then we give them something in the sign that says when you fall through the hole, it's on you. My answer is we're not showing unsafe houses.
All right, I'd like to point out two things about this form. First, it's not just for open houses, it's also for property visits. So even if there is something by appointment, I think it would be a good idea to use it in general. And I do mean only in general. If a listing agent has actual knowledge of a specific defect or a specific animal issue, this form is only going to provide modest protection for the seller and listing agent. The listing agent needs to actually make a much clearer disclosure as to the specific risks at the property. This would be a good document for a buyer's agent to provide to buyers, to give them a good sense of what to look out for, especially on the issue of recording devices and the fact that they need to take care of their children. But this form is not going to protect sellers or listing agents who fail to provide adequate warning of specific known risks. So although this might be a good idea in some respects, This form isn't going to make anybody bulletproof.
So by the way, people, this is why she gets paid the big bucks. Okay, what's next?
Dan, you want to tell us about this whole other list of CAR's revised forms that we're not really going to talk about?
Yes, are you ready for it? Because we now have statewide rent and eviction controls, and for those of you who are here in San Francisco, this is what you say to the rest of the state. Welcome to the party, people. And I promise you that all across the state this year, when this thing went into effect, they said to themselves, what the hell is eviction control? They had no idea that when the lease ended and went month to month, you couldn't simply ask the people to leave. In the old days, if they had been there for more than a year, you had to send them a 60-day notice, and they had to actually leave. Is that true in San Francisco? Definitely not. Everything is now eviction controlled. Is that true across the state? It depends on the property. It depends on the lease. It depends on the notices that have been given. It's complicated. And so all of these forms were modified to explain it's complicated and try to draft around that complication. There was honestly a discussion at CAR that said, listen, should we just ditch all these forms and send everybody to a local landlord attorney? And the answer was that's politically not going to be too tenable at this moment. So we're going to try our best to change these forms. So here's what you need to know. They've all changed to accommodate statewide rent and eviction controls. If you're not practicing in this area, if this is not your specialty, refer this out, please. End of discussion.
Okay.
So are they required forms, Dan?
Well, what is our definition of a required form? At some point when you want to get somebody out, there's a statute that says how you got to do that and what forms need to be served. It doesn't have to be this exact form, and you're not the one who should be doing it anyway. So that's what I say about required.
Yeah, I don't see them as being required at all because you and I agree, hopefully our agents aren't doing this type of work. Bill, we have a revised TDS. You want to walk us through it?
Yes, so we do have a new TDS, and this is very important. There's a major change here that everybody needs to be aware of on the listing side in particular. So a statutory definition of a completed TDS was changed. So now the seller has to complete sections 1 and 2, and the listing agent has to complete section 3, which would be the report of their diligent visual inspection, which we do routinely on the AVID form. But basically, the new form shows that, hold on a second, that it's got a date at the top, and the revision date on the bottom is the one you should not be using. It's from 2014, and there are only 2 options on the old form. So the new form has a 3rd box and a new revision date, and it has the new box says it's the 3rd one. It says no substituted disclosures for this transfer. Up until now, ever since the TDS was around, we only had the 2 boxes, and it was generally understood that if the seller didn't check either of those boxes, they made the choice of not checking anything. Now, with this new box, it is an obligation for your seller to check one of the boxes, and we're going to talk in a minute about which boxes should be checked. But so the new TDS has the June 2020 version date shown at the top, and the question is now, is this a required form? And the answer is yes, it is required by 1102 of the Civil Code. In fact, if you look in 1102.6, the TDS, exactly as you use it, exactly as you see it, is reprinted in the statute itself. So it is in the first category of the most required forms. And so the question then becomes, what are the seller's options for completing section 1? Well, the seller could check box 1, which says those disclosures and reports received by the buyer during the transaction. Or they could check box 2, but then you have to add something in there as to what additional inspections and reports are needed to be included or are going to be included. And The third box would be the seller can check, the third option is you could check both 1 and 2, that, you know, the ones specified in the contract and those ones received by the buyer that are identified in 2, both of those could be done, but you can't, and you could check box 3, which says, no, we're not adding any substituted disclosures. That's exactly what we've done for the last 30 plus years. So that is definitely an option. What can't be done is they should not be checking all 3 because that doesn't work. Okay. If you check box 3, do not check box 1 or 2. All right, so the listing agents need to read what they've wrote and basically make sure before you deliver the TDS to the buyer agent, be sure that you check to make sure that A box has been completed in paragraph or section 1 of the TDS.
You know, I got a question here in the Q&As that asked about Glide and whether or not it knows about this and populates for it. Not only does it know about it, doesn't let the seller move on without answering one of these, and it won't allow the inconsistent all 3 boxes checked. So that's convenient. One of the difficulties you have with it as an agent when you're in the traditional way of sitting with your clients is making sure that they've actually completed these forms, right? So as an agent, you have a fiduciary duty to make sure your client understands their disclosure obligations and to assist them in meeting them. And so at the very minimum, you had to make sure that everything was done. And if this isn't done, then the form isn't complete, and that's a big deal. And that's why some of those automated services like Glide are very helpful. Full disclosure, I consult with Glide, and in theory, someday I could actually make money off of it. So far, I've gotten 1 free dinner, just so you know.
That takes us to the next form, which is the Disclosure Information Advisory Form. CAR copied this document from something that Bill and I created several years back, and which, because I am a consultant for Glide, Glide also has this form, at least in a comparable format. So because of the change of the TDS, obviously now more information had to be added to the DIA regarding section 1. The CAR version does not really explain all 3 of the options. The version of the DIA that is used by Glide actually does explain the 3 options in a form that is very comparable to what Bill explained on his slide. One other change to the DIA is the moving of the information regarding question 16 to the bottom of the section regarding the TDS, which is really where it belongs because the form proceeds in correct order. So one other little note on this, the DIA in the seller property questionnaire section now makes it clear that although the SPQ is not a required form except by contract, that it does include information that is required by law. So is this a required form?
No.
Interesting enough, I could honestly say it's not in a statute. Its content isn't required by anything. Is it the standard of care? Yes, in many areas it is the standard of care, but I think what is going to happen is that as more brokers understand the importance of getting sellers to really grasp what they need to know before they start completing their disclosure obligations, I believe that more brokers are going to require this as part of their company policy. Dan,
And I would add
anything on that?
Yeah, thank you, Vickie. I would add on that I would strongly recommend that listing agents provide this to your seller at the time you're taking the listing and providing the disclosure documents. You're educating the seller as to what their disclosure obligations are. Hallmarks of failure of a seller to disclose in a deposition or a trial, sellers often say, you know what, I would have disclosed that if my agent would have told me I was supposed to disclose a prior lawsuit, or that the neighbor told me that my fence was on their property, or that they're selling drugs across the street. I didn't know I was supposed to disclose all that stuff, or I was supposed to disclose all the documents I have in my possession that affect value or desirability. Providing them the sellers this form and actually going through it with them, I think is an important part of the listing process. And it also is risk management protection for you, because if that lawsuit hits, this is your evidence that you took that additional step to educate your seller about what they should have disclosed.
And depending on what you do as your matter of practice, the best time to do this might be immediately upon having the listing agreement signed. So I know that that's often your focus, which is getting the listing agreement signed, and I certainly don't begrudge you that focus. But after it's signed, now would be a great time to sit down and talk about some of these things. Let's talk about our marketing plan. Let's talk about our disclosure obligations. Let's talk about our inspection reports, what we're going to do. And when we talk about our disclosure obligations, here's the seller's advisory. Here's something called the disclosure information advisory. It helps us figure out what all these things are. You've probably already heard of the transfer disclosure statement. That's at the foundation of some of the things that are required, but there are others. Let's just take a few minutes to go through this. I don't want this to be a surprise to you when we set up all of these documents for preparation in next week or whenever we do it.
Our next new form, revised form, is the representative capacity signature disclosure for buyers. There's two changes. One's very minor. Just above the acknowledgement of receipt box, it now makes it clear the acknowledgement is to be done by the other party, which, since this is for the buyer representative, the other party would be the seller. And there's a new box that can be used when there is an assignment of the agreement. So is this a required form, gentlemen?
Well, that's a good question. I really don't know. So I'm going to answer this cold. Are you ready for my cold answer? Here's my cold answer.
I'd like you to warm it up just a little bit.
All right. So here's the point to this. The signature of Dan Hershkowitz is incomplete if I am signing in a representative capacity. So if I sign the contract as Dan Hershkowitz, that's incomplete. I need to sign the contract as Dan Hershkowitz, trustee of the Hershkowitz Family Trust of 1997. That would be the complete signature. There isn't often enough room for that, or it's a pain in the ass, and we'd like to do it Dan Hershkowitz, trustee. That might also not be complete. The way that we make all of those signatures complete is to incorporate this, which says everywhere you see the name Dan Hershkowitz or Dan Hershkowitz, trustee, he's really signing in his capacity as Dan Hershkowitz, trustee of the Hershkowitz Family Trust of 1996, which is the requirement. So in that sense, you got to do it right one way or the other. This is helping you do it right.
And in the future, when the 2021 RPA comes out, this document won't be needed because the concept will be built directly into the RPA.
What?
Hopefully, yes, Dan, don't you remember? Because we're on that committee together, we decided we were going to do that.
Good for us.
I know, that was great. And hopefully when that happens, people will stop looking at this form as though it somehow works like a power of attorney, that once you sign it, you don't have to sign anything else. This is one of the misconceptions that Bill and I keep seeing that many agents and some brokers have about this form. This is merely a way to make sure that when you see somebody's signature on all of the other documents, that they are not signing as an individual, they are in fact signing in their representative capacity position. So we're running kind of low on time, so I'm going to move on. And Dan, you want to start talking about the new residential listing agreement form, because it's been significantly revised.
Well, you know, even though it has been significantly revised, it's very easy to explain the revisions. And here is the crux of those revisions. This form has been changed to remind us that we are in an era of clear cooperation. It explains to us what clear cooperation is, how it interfaces with our multiple listing services, It does mention and give you the opportunity, if you were at Barry's or one of the 2 MLSs that does not have to cooperate with clear cooperation, that you can check a box and say, that doesn't apply to me. It explains to your client, your seller, that you have the obligation to cooperate and comply with clear cooperation, and therefore will be presenting the property onto the MLS within 1 business day of public marketing, a brief explanation of what that is. And it also interestingly explains that many of the MLSs have come up with a system to help you comply, which is called coming soon. It explains the coming soon concept in the MLS, and it gives consent to you as the agent to use your discretion to enter it into the coming soon to comply with clear cooperation. That's one big thing that it does. And it does one other thing, which is very interesting. It basically takes the SELM information that says the seller is going to exclude the property from the MLS, and it puts that information inside the real estate listing agreement. The idea there, and our hope there, is that over time we will convince all of the local MLSs that they don't need both an SELM and the real estate listing agreement, because it's already inside. And San Francisco is already on board with this, does not require you to necessarily have a separate SELM, has a system to allow you to enter onto the web that you have received the equivalent, and the listing agreement now will be that equivalent. How did I do?
Perfect. Because the other revised form is the seller instruction to exclude listing from the multiple listing service. And if you look closely, the changes between this and the listing agreement are identical. My hope is that other MLSs will emulate what San Francisco has done. And thank you, Dan, for getting that going. The last revised CAR form that we need to just briefly mention is the septic inspection, well inspection, property monument, and propane tank allocation of costs addendum. This is not required at all. This is an addendum to the purchase contract to figure out who is going to do what about all of these rural issues in rural areas where there are propane tanks and people have to determine who gets the remaining gas. I kid you not, there's lots of propane gas cases out there in the boonies. This is a great form, but it is certainly not required. So we now have 3 revised SFAR forms: purchase agreement, the COVID-19 emergency amendment, and the San Francisco seller disclosure for all properties. Dan, why don't you start us off?
Boom, watch how fast I do this. Remember earlier we talked about the new statewide rent control and eviction control laws? Well, they create different tiers of rent control and eviction control in San Francisco. Some things will apply to the state, but not to the local because of the 1979 versus the 15-year rules. This just reminds the parties to the contract that local and statewide rent and eviction control laws do exist, and they severely may impact the right to charge rent, the duration and terms of the tenancy, the number of occupants, the ability to recover possession, the right to move into the property, etc., the right to condo convert. This is a little reminder. This is basically a disclosure stuck inside the contract. Okay?
And you'll note that it, in keeping with the advice that we have been giving earlier in the program, that anyone who has questions is told to seek legal advice from a qualified San Francisco landlord-tenant attorney.
And that is good advice, truly. If your client does not understand these things or has some desire to move into this property or to do anything with these tenants, well, guess what? They need to understand these rights, and the person to help them understand them is a local qualified San Francisco tenant attorney.
Dan,
all right.
You've got the next form too.
This will be even faster. So most of us are using the statewide, if we're using statewide CAA form. That's the COVID addendum or amendment that can be used as an addendum to an existing offer, an addendum to an offer you're drafting, or as an amendment to an existing contract. That's the CAA form. San Francisco has a version which is an amendment to an existing agreement. If you have an existing contract and you're having COVID issues, and if you're saying to yourself, these COVID issues seem to be behind us, people, I'm afraid they're in front of us. And so there will be more and more COVID issues, I'm sure, as things get more and more hairy. Anyhow, if you are in an existing contract and you would like to do the following, you would like to amend the contract to give clarification for the unknowns of these things that you're experiencing, coronavirus delays, for instance, rather than try to fight over the contract and what it means, a contract that does not have a force majeure clause in it, a contract that may or may not have been drafted with a pandemic in mind. You may say, I'd rather have clarity than a fight, so let's pull out this form as an amendment to the existing agreement and decide what if these things happen. Will we delay? Will we not delay? Will we reinstate contingencies that have already been removed? All of that is allowed here. The form itself was amended per me and Vickie and David Perry to make it a little bit better and more clear on those issues. That's it for this form.
Is it required?
No.
It's just a handy dandy document.
It's handy and dandy.
Next, Dan.
Next. Okay. In San Francisco, rather than having an SPQ, we have a San Francisco Seller Disclosure, which is a supplement of sorts to the TDS, where the seller answers additional questions. As you may recall, this form is required whether or not the TDS itself is exempt. The idea here is, since all of these questions are phrased, are you seller aware? Well, the seller, who could be a trustee, who could be the representative of some other entity, nonetheless may be aware of these things, and this is a great way to prompt and gain additional information. This form happens to have a don't know column as well, so even if you were dissatisfied with the preface to all the questions, are you seller aware, you have a don't know column as well. What we have done here is try to make the form, one, better, and that's some of the red line changes, but the formatting has changed. It is now 3 forms in one, as Vickie points out. So those 3 forms go like this. The first 3 pages apply to all properties. And see where it says at the top, San Francisco Seller Disclosure, all properties? That's how you know you're filling this out. If yours is one of all properties, meaning it is, you're filling this thing out. But what if instead yours was a condo? Do we have a separate form within a form for condos, TICs, and co-ops? We do. It's these 2 pages. If your property is not a condo, does not have an HOA, is not a TIC or a co-op, are you obligated to fill out this section? No. No. Or there's one more version. What if your property is a multi-unit or tenant-occupied building? Do we have special questions for you? We do. And by the way, this applies to single-family homes that have illegal or legal in-laws. Okay, that in San Francisco, we don't care whether it's legal or illegal. There are special rights for multi-unit properties, and this particular page is getting those questions that are relevant answered. That is the change here. And by the way, why were some of these individual questions changed? Well, we did our best to bring these questions to the relevant attorneys, for instance, for the TICs, for the co-ops, for the multi-units. We made sure that the questions were formulated to reflect some of the changes in both practice and current law. Okay?
So it's not required to use this form at all, Dan?
No,
not
it's
even
required.
using the SFAR purchase contract?
I'm so sorry, it is contractually required. So if we look at the San Francisco purchase contract, paragraph 19, it talks about statutory and contractual required forms. It says that we will always be providing San Francisco Seller Disclosure, even if we don't provide a TDS. And for those of you who say, wait a minute, when we don't have to do a TDS, we have to do that exempt seller disclosure. Well, actually you don't, because all of the exempt seller disclosure questions are built right in here. So if we went back to the section that says for all properties, you'd see some of those questions like, was there a death on the property in the last, is it 5 years? 3 years, 3 years.
Yeah.
Was there an insurance claim in the last 5 years? Is it in a flood zone, a fire hazard zone, et cetera, et cetera, et cetera?
Great. So that's what we've got for you today on the forms, but we thought we'd also share some other new information because this year we have two important recent appellate decisions. Both are from the Bay Area. The first is Moore versus Teed, which was decided in April. And the second, Owens versus City of Oakland Housing Residential Rent and Relocation Board, which was decided in May. Bill, why don't you take us through Moore versus Teed?
Yes, thank you, Vickie. This case is important because a number of agents help sellers get properties prepared for market by having contractors, landscapers, painters, et cetera, come in. And also some agents help sellers, or excuse me, buyers renovate property with folks that they know or use. And this case addresses the latter. So this comes out of San Francisco. Agent Teed promoted himself online as a real estate agent with over 25 years experience as a building contractor with extensive background in historic restorations. The buyer, Moore, stated that he believed Teed was a general contractor, but Teed, in fact, was not a contractor of any type. Teed convinced the buyer to buy a large San Francisco fixer-upper house for $4.8 million. Buyer was assured that Teed and his team could remodel the home the way Teed wanted it for $900,000. The home was built way back in 1912 and was updated in the 50s. Teed got the selling agent commission, and even though he didn't have a contract with Moore to do any of the construction work, after close of escrow, his team gutted large parts of the house, excavated the lot, but sadly, the foundation was defective. Moore had paid $265,000 of the estimated $900,000 when buyer called the work halt. The buyer hired new experts who determined that the work up to date was not adequate. They took out the what the agent's crew had done and put in a whole new foundation. The buyer then spent a total of $9 million, including the purchase price, to make the home just the way he wanted. Of course, parts of that were extras that were not part of the originally agreed upon $900,000. But Moore wanted Teed and his team to pay for his expenses. So what happened next was that Moore sued Teed and members of his team. The total award against the defendants was $1,900,000, almost $2 million. Moore had settled with all the other defendants for a total of $1 million, and then pursued Teed for the balance. Teed took the case up on appeal, claiming that the measure of damages by the jury was wrong, disputed the amount that he owed, and attorney's fees. In any event, the jury determined that the real estate agent, as an agent for Moore, he owed a fiduciary duty. The jury determined that the agent had defrauded Moore regarding his expertise and contractor license status, and the jury further determined that the agent had induced buyer to alter his position, in other words, buy the house to his detriment. Thus, the agent was liable for any and all damages that Moore suffered, and the only way to compensate the jury was to award Moore additional costs necessary to accomplish the promised revisions. So on appeal, it went up on appeal. The appellate court agreed with the jury. Also, that it stated that a fiduciary should be responsible to compensate his or her principal for the full amount of the loss caused by his or her breach of contractor duty. Moore was also entitled to recover his attorney's fees and costs in suing Teed for fraudulently inducing the buyer to enter into a home improvement contract with his construction team, and was entitled to attorney's fees on appeal based on a rather obscure business professions code section that a great number of attorneys are not familiar with. In any event, so unless your brokerage has a program in place to help clients, agents who on their own want to help prepare a property for sale or do remodeling after close close of escrow should seriously ask yourself these questions. Who's choosing the work to be done, you or the seller? Who's choosing the workers? Same question. Paying for the work either out of your pocket or using the owner's funds that you're holding, which would be exceedingly dangerous. Are you supervising the work? You may be classified as an unlicensed general contractor with full liability for the quality of the work. Take a look at all of those questions. Are any of those license activities? When you start engaging in construction, renovation, supervision of work, those are not DRE licensed activities. So E&O is not going to cover that more than likely. So to protect yourself, if you are engaged in those activities as a real estate licensee, we recommend that you hire your own qualified California real estate attorney to evaluate what you're doing and what you cannot do, and have your own attorney prepare a proper separate agreement. Why is this your responsibility? Again, this is not licensed activity. So if you want to engage in this activity, you should have your own attorney prepare a form for you that discusses in detail what you're going to do, what you're not going to do, and have it as a separate agreement apart from the listing agreement or any other buyer representation agreement. And just be aware that this is a separate area of increasing liability. And with this case now on the books, when a case like this occurs, it becomes one that all attorneys who start researching this area are going to find quickly. Vickie or Dan, do you have a comment addition on that?
Well, some of the questions are, obviously people feel for this person because clearly what they were trying to do was to add value, which is what we're always trying to do. And there's a terrible fine line between adding value and using all of the skills that you have and the knowledge that you have from other sources or other areas of your life. And so I really feel for this agent. I can appreciate what the agent was trying to do. But there is a fine line here. And one of the things that's important is that we also discuss whether or not your E&O would be coverage. And that's one of the questions that's been asked here. And I think that the answer would be, I doubt it, because it's the particular issue here is that you're acting beyond the scope of what a real estate agent is doing. And you're undertaking a different duty, which is a contractor duty, for which you may or may not have insurance.
One of the other things that people should keep in mind with respect to this issue is sometimes sellers change their mind. And I've handled half a dozen cases over the years where agents have done such a fabulous job of sprucing the property up that the sellers decide they don't want to leave. The problem for the agents in those situations was, unfortunately, that they tied the reimbursement that they were entitled to receive to the successful close of escrow. With that gone, since the sellers aren't going to sell, or in one case they sold, but with a different broker, then the ability to obtain reimbursement becomes more difficult. At that point, the role that the agent played isn't a role of an agent, but could be of an unlicensed general contractor. In that situation, unfortunately, the agents have no right to reimbursement if they are not licensed as a contractor. The only right to reimbursement is for the first $500. And when you've expended $35,000, $50,000, being told that you're only legally entitled to recoup $500 is not very pleasant. So
I'd like to add one more thing on Vickie very quickly. One of the lessons from this case, I think, is agents need to be cautious on how you market yourself and represent your skill set. That is going to be, I think, where plaintiffs' attorneys are going to start looking is what did you say about yourself that might have been something that induced a buyer to work with you and do what you were suggesting. So be careful on that.
So the whole point of having the separate agreement and having it properly drafted by a qualified California real estate attorney is that you can build into the agreement the basis upon which you are working, as well as the reimbursement rights. So this is a very difficult area of the law. I have been working with another attorney who has been trying to help a real estate broker create a separate agreement. The last draft I saw had 12 pages to it. So
Ouch.
keep in mind, this is not the type of agreement that you should be preparing for yourself. Dan, did you want to throw in anything else
I think you did
before we
well.
go on?
No, thank you. Let's continue, and we only have one more.
So our next case is Owens versus City of Oakland Housing Residential Rent and Relocation Board. Mr. Owens owned and resided in a 4-bedroom single-family dwelling in Oakland. He rented out 3 individual bedrooms to 3 unrelated tenants. He got into a dispute with one of the tenants. The nature of the complaint isn't all that important. What is important is that she complained to the Rent Adjustment Board. Owens claimed that he and his home were not subject to the jurisdiction of the Oakland Rent Control Board because single-family dwellings are exempt from local rent control under the Costa-Hawkins Act. It wasn't too surprising to many people, especially landlord-tenant attorneys in San Francisco, that the rent board sided with the tenant. After losing at all of the various different administrative levels, Owens went to the Superior Court to challenge the rent board's decision. The trial court described the legal principle at stake as follows. At issue is the question of law whether Owens's 4-bedroom single-family detached home is exempt from the rent control ordinance under the Costa-Hawkins Act because it is alienable separate from the title to any other dwelling unit, which is the language from the Costa-Hawkins Act, and that he may rent those bedrooms to individual tenants without complying with the local rent control rules. The trial court determined that each bedroom was a separate dwelling unit, and thus the court also found in favor of the tenant. Owens took the case up on appeal. The California Association of Realtors filed an amicus brief in support of Owens' analysis that the property was exempt from rent control under Costa-Hawkins. The appellate decision came as a bit of a shock to some. The appellate court agreed with the trial court that the relevant dwelling unit in question is not Owens' entire single-family home, but rather each of the rooms that he rented out to the unrelated tenants. The appellate court held those units, those rooms, are not exempt from rent control, and thus the rent control laws in Oakland do apply to those units. The significance of this decision is just another reminder of the inclination of California judges to find ways to favor tenants and impose rent control laws. Since this decision was a surprise for CAR, it is indicative of the ever-changing landlord-tenant laws in the state, although I've heard from 2 San Francisco landlord-tenant specialists who say they've always believed that the individual rooms were also subject to rent control. So because of the vagaries of landlord-tenant law, real estate agents should not be opining about anything in that area of the law. Instead, you should immediately refer the clients to someone who knows all of the laws in the jurisdiction where the property is located. In other words, you need to have the clients consult a, drum roll please, qualified local landlord-tenant attorney. We cannot shout this message enough. We started with it and we're ending with it. Gentlemen, did you wish to add anything at this point?
Well, you know what's funny is when I shared this case with some of the local landlord attorneys in San Francisco, you know what they said? Duh.
Duh.
Right. And they said, you know, this is San Francisco. Of course, this presumption is going to be made in the favor of the tenants and against the landlord. But the point here really is, if you didn't know this and your client asked you about this, what would you have told your client? And I hope that what you would have told your client is, that's a really interesting question. I'm not a landlord specialist. Let's go get you in front of a local landlord attorney so we can discuss the implications here and how this might impact what we do with your property.
Well, hopefully we've all learned a big lesson. San Francisco is ahead of everybody else because in other parts of the state, the position that CAR took in the Owens case is, I believe, one of the big factors that led to this particular appeal. So we want to thank you all for attending our program today. Dan, are there any other questions that have come in that need to be answered?
Well, there were a few, but I'd rather leave them wanting more. But one of the questions was, when do the forms drop? And so CAR forms have dropped yesterday, in fact, and SFAR anytime now, probably next week. So with that, I would like to, just as a point of personal preference, personal something, I forgot what they call it, I want to say thank you very much to SFAR. We love doing these things, and it's an opportunity for me to be on the same stage with Bill Jansen and Vickie Naidorf, which truly is an honor. I don't mean to geek out, but in terms of risk management, this is the standard in the state, and it's lovely to be their colleague. Thank you very much for having me.
Well, thank you for inviting us, Dan. Bill and I wouldn't be here but for your invitation. So it was our pleasure to participate and to share the slides with you.
Yes, indeed. And are there any questions?
Nope.
I think we're good.
We are.
All right.
All right.
Well, thank you
you,
all.
everyone. Bye.
Okay, thank you. Bye-bye, everybody.